Hello everyone, welcome back to the channel. So, in this series, we will be reading and discussing important judgments of the Honorable Supreme Court of India. And the aim of the series is to develop habit of reading judgments. Yes, it is something very scary initially, but also something that is very important to understand legal principles, reasoning, and application of law in real situations. This series will be beneficial for everyone from judicial aspirants to law students struggling in the journey of law school. So, this is the place to start your habit of reading judgments. Let's begin with today's judgment. So, the judgment for today is Harish Rana versus Union of India and others. Now, um, the just a second. Here, this is called the cause title. Okay, let's first understand what is the issue here. Article 21 states that we have right to life. But does that also mean that we have right to die? Here comes passive euthanasia. Okay? So whether passive euthanasia can be read into Article 21? Can it be claimed as a right? Now, before going into this issue directly with the starting with the judgment, let's first try and understand a brief background of how passive euthanasia has been dealt through years. So, starting in 1994, we have the case of P. Rathinam versus Union of India. In this case, the constitutional validity of Section 309 of IPC was challenged. So, 309 IPC dealt with someone who is attempting to commit suicide, and the punishment prescribed was up to 1 year. And here, the Honorable Supreme Court had stated that under Article 19, wherein we have right to freedom of speech, there is also a complementary right to it, that we have the right to not to speak also therein. Similarly, if you draw a parallel under Article 21, we have right to life. Why can't we have right to die? Similarly, on this basis, Section 309 was held as unconstitutional by the Honorable Court. Now, this was challenged and overturned in your case of 1996, Gyan Kaur versus State of Punjab. Here, the Honorable Court says that Article 21 does not include right to die. Therefore, this 5-judge bench held Article 21, no right to die. Okay. Passive euthanasia was not allowed, and this was overruled. Let's now come to 2006. What happens here? After almost 10 years, Law Commission report comes. It is 196 report, which states that there must be some law to protect the terminally ill patients who refuse medical treatment, artificial nutrition, or hydration from Section 309 of IPC. Now, here the focus was on terminally ill patients. Okay, so from the ambit of 309, क्योंकि P. Rathinam was very vast, it just declared 309 as unconstitutional, so everyone had right to die, right? Here in the demand was specifically pertaining to terminally ill people who were suffering from terminal illness and which causes extreme pain and suffering according to reasonable medical opinion and will inevitably cause untimely death of the patient. Okay, so a recommendation was put in here for the law which did not came to being. So again in 2008 a recommendation comes from 210th Law Commission report, which states that 309 is inhuman. It should be struck down as unconstitutional because suicide was now considered as a diseased condition of mind. So mental health rights and all were evolving slowly, and suicide then was understood as an aspect of your mental health. It's a condition wherein you can't punish, it deserves treatment and not punishment. So now you are inflicting additional penalty on a person who is already suffering from agony is inhuman in itself. So that's why the report was moved in 2008. Again, no law, a bill was passed, but it did not did not pass, and no act was there. Coming to 2011, very important case of Aruna Schonborg versus Union of India, जहाँ पे the court held that court is the ultimate decider of what is best for the patient, and it also extended the power to high courts under Article 226 to allow passive euthanasia. From here in 2011, passive euthanasia was allowed, and who could? Only the courts, Supreme Court and High Court under 226. Okay, and the principle invoked herein was parens patriae, that is, state is the parent. Okay, so the court can step in and serve as the guardian and decide what could be the possibility of granting permission for passive euthanasia. So now it was allowed, but it was conditional that if the court deems it fit, it can be allowed. Otherwise, it will not be allowed. Now, in 2016, a draft bill that was passed, that was published by the Ministry of Health and Family, medical treatment of terminally ill patients Protection of Patients and Medical Practitioners Bill was invited. It invited also public comments, but again, no further steps were taken and nothing happened. So this bill just lapses. Now, after 2016, in 2018 comes Common Cause Petition, wherein right to die with dignity was recognized under Article 21 itself. Now, herein, comprehensive guidelines were also laid down by the court that for withdrawal and withholding of the medical treatment in, since there is no legislative framework yet, so the court had given certain guidelines in detail. Now, this 2018 judgments guidelines are also covered under the judgment itself, so we can look into it further when we read the judgment. Then now comes this case. Here, let's see how the law has evolved and what has changed. What is the position now after this 2018 judgment? So from 1994 to 2018, we had all these cases, and in 2026 comes this case. So let's start with the factual metrics itself. God asks no man whether he will accept life. That is not the choice. You must take it. The only choice is how. So the above words of Henry Ward Beecher assume great significance in the present case, more particularly when the courts are asked to give their decision on question whether an individual can choose to accept life by preferring to die. The famous Shakespearean dilemma of to be or not to be, which had so far remained as a literary quote, is now being used for judicial interpretation to canvass the liberty to die. Now, we might not be able to cover the whole judgment in one lecture. So, try and we'll try and cover as much as we can because it's a lengthy judgment. So, stay with me and try to read it by yourself as well. The present miscellaneous application has been filed by mentally and physically incapacitated applicant, namely Harish Rana, through his parents in captioned SLP that came to be disposed of by this court, wide order dated 8/11/2024. By way of the said order, this court resolved the matter between the parties by ensuring that adequate care and necessary treatment are provided to the applicant, included but not limited to provision of home care at expense of the respondents. Now, this is giving a brief background of how the case has come to the Honorable Court again. So earlier there was an SLP which was decided. Now in that SLP this MA is being filed. Here SLP was filed from the order of the Honorable High Court, Delhi High Court, wherein High Court dismissed the writ petition that applicant was not being kept alive mechanically and he was able to sustain himself without any extra or external medical aid. So Delhi High Court had refused permission for passive euthanasia. जो हमने देखा था that high courts were also given under 226 the power to decide. Now aggrieved by said, the applicant through his parents preferred the SLP and SLP again was dismissed. Now, owing to the applicant's continued vegetative existence, which violates his right to live with dignity, under Article 21, the parents have moved wide the miscellaneous application, seeking constitution and referral of applicant's case to primary medical board, and declaration that provision of clinically assisted nutrition and hydration, which is currently being administered to him through a PEG tube, is medical treatment. Okay, so in the first paragraphs itself, it encapsulates why the applicants are here, what was the legislative history, as in what happened in the lower courts, and what is the relief sought from this honorable court. Here, the parents have also prayed that suitability of continuation of CNH be assessed in accordance with ruling of 5-judge bench in Common Cause 2018 judgment and guidelines ascribed therein, which later modified to some extent by the 2023 judgment. For ease of reference, the guidelines exist as laid down in 2018 and modified in 2023 will hereinafter refer to as common cause guidelines. Okay. So now moving to the factual metrics. So here you can see that the applicant was 32 years old now, and when he was 20 years old he fell down from fourth floor of his PG and he suffered grave injuries, and he was he was basically uh, suffering from such severe injuries that he remained in vegetative state only from and even if after he was discharged he was again admitted, and he was being administered CNH here. Okay. Which now requires replacement at a hospital every 2 months. Now, again, the patients, like the medical records of the applicant has been put forth here, that the state is pathetic, like he is not being able to um, do the basic chores. He doesn't know, he doesn't he can't move, there is no body movement. So all that is described here. The only thing from legal perspective what is important here is what is medical treatment, that we will analyze as per the common cause guidelines also, that whether this constituted medical treatment, so that could passive euthanasia be allowed. Now, further, it says that he suffers from 100% physical disability. Now, all this is merely factual and does not, as such, form part of much legal arguments or something. So we can just skip to the submissions. You can just skim through the facts once. Now, submissions on behalf of the applicant. The applicant has herein referenced Common Cause 2018 on withdrawal and withholding of medical treatment. So these guidelines were laid down by the Honorable Court, and whether within these guidelines the present case falls or not, whether this was medical treatment or not, then the judgment in 2018 and 2023 does not contemplate routine or initial adjudication by Constitutional Court in such matters. On the contrary, the mechanism for withdrawal in such cases where no AMD exists is predicated on the hospital in which patient is undergoing treatment, which is required to be constitute a primary medical board, followed by a secondary medical board. Here, this was where the cause of action arises because they should have first, the hospital should have first formed the first medical board and or like primary medical board and then secondary medical board. But then the applicant had to go for judicial intervention by invoking Article 226, and that is when there is a disagreement between primary and secondary medical board. And the High Court role was limited to supervisory and stepping in only when medical decision making process reaches an impasse, that there is no decision as such. Therein, the High Court interrupts. Ordinarily, therefore, courts are not required to adjudicate in determination of whether medical treatment ought to be withdrawn or withheld. So, right, the work of court is not to determine uh, whether medical treatment is to be withdrawn or withheld. No. However, in present case, owing to the absence of an institutional mechanism that is important, that there is no institutional mechanism to trigger the process for a patient who was being provided long-term home-based care, and the family was left with no alternative than to approach Article 226. So this shows that there was no legislative mechanism. How could they have you know asked the hospital to form these boards? And so there that highlights why the honorable court and the law commission reports, they highlight the need for a legislation on this issue. So this determination of whether the medical treatment should be continued or not should be in accordance with the common cause guidelines. Now let's move to submissions. Let's skip the submissions on behalf of Union of India that you can read once, and come to the core concepts underlying the decision in Common Cause 2018, which is important. Detailed perusal of facts makes it evident that this case revolves around one central issue: whether, when, and on what legal basis can medical treatment be withdrawn or withheld. तो क्या मेडिकल ट्रीटमेंट विड्रॉ किया जा सकता है, कब किया जा सकता है, और किस बेसिस पे किया जा सकता है? These are the three main questions. The definitive word on this subject lies in the decision rendered by a 5-judge bench in Common Cause 2018. The decision forms the essential foundation upon which our current decision must rest, and we deem it not only important but absolutely necessary to begin by discussing the principles later. The decision arose from reference by a 3-judge bench of this court, which sought to inter alia resolve certain inconsistencies which existed in earlier judicial pronouncements and provide some clarity on the right to die with dignity and other concomitant issues such as euthanasia. The primary contention in 2018 were declaration to the effect that right to die with dignity forms part of Article 21 and legal recognition of living wills, AMD attorney authorization, through which individuals could specify their wish to forego medical treatment in the future and authorize an attorney to make such decision on their behalf should they lose their capacity to do so. While examining these contentions, this court found it necessary to discuss the concepts of both active and passive euthanasia and determine their permissibility within our constitutional framework. The Common Cause deals with these two issues. First, whether Article 21 includes within its ambit the right to die with dignity, and secondly, whether living wills can be recognized or not, AMG or attorney authorization. Now, it was held Right to live inherently includes right to die with dignity. So, P. Rathinam judgment ultimately here comes to play. And secondly, passive euthanasia and AMD are both legal and permissible under the framework of Article 21 because it is only uh, the correct understanding of right to die with dignity that passive euthanasia has to be allowed. It only flows from there, right? Now, uh, Honorable Justice Deepak Mishra, in his leading opinion, prescribed a detailed set of guidelines governing the execution and enforcement of AMDs. He laid down mandatory procedure for deciding whether medical treatment must be terminated, covering both scenarios where AMD existed and where it was absent. These guidelines and the prescribed procedure received the concurrence of the other members of the bench and it was affirmed. Now, in 2023, an MA was moved before this court in 2018 case seeking certain clarifications on the judgment, specifically regarding challenges in practical implementation of the guidelines as laid down therein. So जो 2013 है, it deals with these. Recognizing the procedural difficulties faced by patients and medical practitioners alike, this court modified and streamlined the guideline to ensure that they remain workable. So 2013 guidelines, they were modified and streamlined. All right. Throughout this judgment, we have taken care to refer to these updated guidelines wherever applicable. Now, let's delve deeper into certain substantive aspects. So, our analysis will focus on following core areas: conceptual distinction between active and passive euthanasia. First, very important that what is active euthanasia and what is passive euthanasia. The constitutional basis for permitting passive euthanasia under Article 21 and the impermissibility of active euthanasia. So, one hand, passive euthanasia क्या है, active euthanasia क्या है, passive euthanasia if allowed, उसका constitutional basis क्या है, and active euthanasia, why is it not allowed under Article 21, and what is the permissibility of AMDs and the procedure used to determine whether medical treatment ought to be withdrawn or withheld. So these are the core questions that are involved with the issue of passive euthanasia herein. So let's today just cover this first issue, that is active and passive euthanasia. So the discourse on euthanasia is rendered complex by problems of uncertain and shifting description of key concepts. Therefore, he noted that in examining legality of euthanasia, clarity on terminology is of absolute essence. This is more so now, where there is a clear ruling to the effect that only passive euthanasia is permissible. The legality of medical professionals' action often depends entirely on which side this conceptual line their action falls. If our understanding of active and passive euthanasia is imprecise, it would breed a precarious environment and consequently render any decision making ambiguous. More critically, such confusion leaves medical practitioners in constant danger of unwittingly violating the law and conversely withholding necessary care out of an unfounded fear of legal reprisal. We therefore find it imperative to delineate the boundaries between active and passive euthanasia with absolute clarity. At this juncture, it is essential to examine the meaning attributed to terms active and passive euthanasia and Common Cause 2018 in each of the four concurring opinions, which are reproduced. It is to be borne in mind that passive euthanasia fundamentally connotes absence of any overt act, either by patient or by doctor. In active euthanasia, a specific overt act is done to end the patient's life, whereas in passive euthanasia, something is not done which is necessary for preserving the patient's life. So, this is very important that in active, you actively take part in ending someone's life. Whereas in passive, you just refrain from doing something, which is the reason that the life of other person is going on, right? So that's the line where active and passive euthanasia falls. So if you do an act that actively takes life of a person, it comes to active. And if it just simply is not doing something which is very necessary for preserving the life of a person, then it falls in passive euthanasia, which is allowed. Then, contrary to the above, in legal parlance, euthanasia has since come to be recognized as two distinct types. First is active euthanasia, where death is caused by administration of a lethal injection or drugs. Active euthanasia includes physician assisted suicide, wherein the injection or drugs are supplied by physician, but the act of administration is undertaken by the patient himself. Passive euthanasia occurs when medical practitioners do not provide life sustaining treatment or remove patients from life sustaining treatment. This could include disconnecting life support machines or feeding tubes, or not carrying out life saving operations, or providing life extending drugs. So, here you clearly understand what is the difference. Let's again go here. So, active euthanasia is a positive contribution to acceleration of death. Passive euthanasia is omission of steps which might otherwise sustain life. So, passive here denotes the withdrawal or withholding of medical treatment. Then again, euthanasia suggests is an act which leads to good death. Some positive act is necessary to characterize the action as euthanasia. Withdrawal of medical assistance or medical devices which artificially prolong the life cannot be regarded as an act to achieve a good death. So, all these are the various definitions. On examination of the excerpts above, it is apparent that while descriptions of the term active and passive vary at granular level across four concurring opinions, they converge on a single broader understanding. The Constitution Bench consistently characterizes active euthanasia as a positive or overt act, such as administration of lethal injection or drug which serves to either cause death or directly accelerate it. In contrast, passive euthanasia is defined by absence of an overt act. It is categorized by an omission and primarily encompasses the withdrawal or withholding of medical treatment that would otherwise sustain or preserve life. At first blush, it would appear that the primary distinction between active and passive euthanasia rests solely on the binary of acts versus omissions. Such an understanding is only natural. Indeed, in the preceding paragraph, we ourselves have used phrases like positive and overt acts to describe active euthanasia, while characterizing passive euthanasia through terms such as omission, absence of an overt act, or decision not to intervene. However, we must caution the distinction between the two is based on simplistic dichotomy of act versus omission would be problematic. So here it is very important to pay attention to this. While passive euthanasia is defined by withdrawal, the physical process of withdrawing, for instance, switching off a ventilator or removing a feeding tube, requires a positive physical movement. If we were to imply the simplistic act versus omission test, such could be misconstrued as active measures. This would potentially place them outside legal protections afforded to passive euthanasia. Now, how do we differentiate between the two is here. The complexity of this issue is further compounded by extensive academic discourse regarding precise meaning to be attributed to acts and omissions. We need not delve into this, as doing so would only further obscure the jurisprudence surrounding active and passive euthanasia. For our present purposes, it's sufficient to observe that while the distinction is partially rooted in conventional understanding of acts and omissions that the binary alone does not complete the legal picture. So act and omission forms important part of the definition but is not entirely the definition. It is clear that a more nuanced approach is required in order to understand the difference between active and passive euthanasia, one that allows for difference on the basis of act and omission to exist broadly, but one that also provides more grounding on the other facets. What would these facets include? A closer look at this would tell us. So, while scrutinizing the distinction between active and passive euthanasia, the paramount aspect is foreseeing the hastening of death. The said view has been propagated in several decisions all over the world. Supreme Court of Canada in Rodriguez versus Attorney General of Canada drew the distinction between these two forms of euthanasia on the basis of intention. Echoing to a similar view, Supreme Court of US affirmed the said distinction on the basis of intention. In Veco, wherein Rehnquist CJ observed that the said distinction coheres with the fundamental legal principles of causation and intention. In such cases, when the death of a patient occurs due to removal of life supporting measures, the patient dies due to an underlying fatal disease without any intervening act on part of the doctor or medical practitioner. Whereas in cases coming within the purview of active euthanasia, for example, when patient ingests legal medication, he is killed by that medication. So the causation and intention principle is important here. There is an inherent difference between these two, as former entails this we have read. And then here, passive euthanasia occurs when medical practitioners do not provide life sustaining treatment or remove patients' life from life sustaining treatment. This could include disconnecting life support and all these things. And in such cases, the omission by medical practitioner is not treated as cause of death. Instead, the patient is understood to have died because of his underlying condition. So here the cause of death is not linked to this act, right? But in active euthanasia, the cause of death is your act only. So that is the main difference. Again, reiterating the qualitative difference between positive medical intervention, which terminates life, and a decision to not put a patient or artificial life support, which will not artificially prolong life. The former brings premature extinction of life, later does not delay the end of life beyond its natural endpoint. So if someone has died, it cannot be prolonged because you are giving some ventilation support or other medical treatment. All right, so it's the extension, but other one is in reverse direction, that you would have died a natural death later on, but today you took some medication or some injection and you died today. So that is active euthanasia. Now, what is the purpose? It is conceived with purpose of not prolonging the life of the patient by artificial medical intervention. Both these methods, both in the case of a withdrawal of artificial support as well as in non-intervention, passive euthanasia allows for life to ebb away and to end in natural course. In contrast, active euthanasia results in consequence of shortening a life by a positive act of medical intervention. Now, passive euthanasia, whether in form of withholding or withdrawing treatment, has effect of removing, or as the case may be, not providing supportive treatment. Its effect is to allow individual to continue to exist till the end of natural span of life. Active euthanasia involves hastening of death, and lifespan is curtailed by specific act designed to bring an end to life. So, all these definitions makes it clear the difference between passive and active euthanasia. And even if, for example, if some note comes on the distinction between the two, now you can take the material from here, note down some important lines that might help you later on in your examinations. So yeah, make a note on these. Here, I think we are done with this issue of active and passive euthanasia. Let's just read the concluding remarks and then move to the next issue. In summation, the essential distinction transcends the simplistic binary of acts and omission. Active euthanasia is characterized by causing death because it introduces an external and intrusive agency such as lethal injection, an intervention that disrupts the natural path towards death. Conversely, passive euthanasia is understood as allowing death to occur or letting die by withdrawing or withholding a medical treatment that was otherwise prolonging life. The physician allows the original harm causing event to run its natural course, returning the patient to their natural path towards death. When viewed through this lens, the role of acts and omission also becomes clear. While the physical withdrawal of treatment may involve an act, its effect is an omission to treat. By shifting the focus from muscle movement to conduct's ultimate effect, there is a recognition that such interventions are in substance omissions. So, that is the concluding remarks on the difference between active and passive euthanasia. For today, we'll just cover thus much. Let's cover the rest of the judgment in the next lecture. I look forward to meeting you guys again in the next lecture so we can continue reading. And I hope you'll read this thoroughly and do make a note on the difference between passive and active euthanasia. You can also share in the comment section. Thank you so much for watching the video. Please like, share, and comment also.